What's up, viewers, subscribers, and agents alike? It's your boy Light Luciferian Prince coming at you once again this morning. You know, who knows? May come at you later on this evening with something. Who knows? Never feel like dropping something. Drop something. You ever shake? This video doesn't constitute legal advice. The sole purpose is for informational and educational purposes only, because we're going to touch on some basis of what I spoke about in my last video. Now, I'm going to use something that I love, quotations that pretty much inspire me to do what I do. And one of them I particularly have to say in regards to this is, again, from Leonardo da Vinci. No, I don't particularly favor Eurocentric ideology, but I do realize that we live in a culture that's based upon it. So I'm gonna basically simplify it in regards to this video and break it down for you, so you know where I'm coming from. For the idea, not the content of the person. Patience serves as a protection against wrongs, as clothes do against cold. For if you put on more clothes as the cold increases, it will have no power to hurt you. So in like manner, you must grow in patience when you meet with great wrongs, and they will be powerless against your peace of mind. That is from Leonardo da Vinci. Great quote. Great quote. In regards to this video, it's going to be titled Federal Children. Are we owned by the government? Now, selectively, there are some people who will debate whether or not they're not, whether or not they may be, whether or not there's may, whether or not it's up or down. Who knows? But what we will address is the history first. Then we'll go into the correction procedure at a later time, because I want people to get the full-fledged education. I don't want to give a half-hearted approach. I don't want to give an, so to speak, all-out misinterpretation. So I'm going to read from a source, which I'm going to keep private for good reason, but it's a few pages, and I got to keep stuff secret, you know what I'm saying? You want the documentation, you're going to have to contact me privately, because these bitches are stealing on YouTube. No originality, culture vultures, trust me. And it's basically going to talk about, are we owned by the federal government? This is a question. This is not a statement saying yeah. This is not a statement saying we are. This is not a statement saying maybe. This is just one of those things that we just have to really look in from a historical precedent. So I don't want people to get overwhelmed thinking that I'm advocating the fact that maybe it is true, because I know it's not. And we're going to get to it now. My lips are big, so pause me if, I actually say something and I bumble a little bit in regards to these videos. Let me go ahead and proceed. In 1921, the Federal Shepherd-Towner Maternity Act created the birth registration, in quotation marks, what we know as the birth certificate. It was known as the Maternity Act and was sold to the American people as a law that would reduce maternal and infant mortality, protect the health of mothers and infants, and for other purposes. Let that sink in. One of those other purposes provided for state agencies and overseeing of its operations and expenditures. What it really did was create a federal birth registry, which exists today, creating federal children. This government of parens patriae now legislates for American children that they are owned by the federal government through the daily public school enrollment process and for continuing licensing requirements for most aspects of daily life. These children grow up to be adults indoctrinated in those things necessary to carry out our activities that exist in what we call a free country. Before 1921, the records of births and names of children were entered into the family Bibles, as were recorded of marriages and deaths. These records were readily accepted by both the family and the law of official records. Since 1921, the American people have been registering the births and names of their children with the government of the state in which they are born, even though there is no federal law requiring it. Think about it. The state tells you that you're registering your child's birth through a birth certificate serves proof that he or she was born in the United States, in the lowercase sense, not the uppercase U.S., right? Thereby making him or her a United States citizen, uppercase. For the past several years, a Social Security number has been mandated by the federal government to be issued at birth. The Social Security number is one of those other purposes. It serves as a means of lifelong tracking of the one whose name is on the birth certificate. In 1933, the United States of America corporate government was declared bankrupt. President Roosevelt, the governors of the then 48 states, pledged the full faith and credit of each of their states, including the citizenry as collateral, for loans of credit from the Federal Reserve System. To wit, full faith and credit, the clause of the United States Constitution, Article 4, Section 1, which provides that the various states must recognize the legislative acts, public records, and judicial decisions of other states within the United States. It requires that foreign judgment be given to such faith and credit as it had by law or usage of its state and origin, that foreign statutes have the same force and effect to which they are entitled in the home state, and that a judgment of record shall have the same faith, credit, conclusive effect, and obligatory force in other states as it has by law or usage in the state from whence taken. Black's Law Dictionary, 4th edition and 6th edition, page 672. After receiving the information of live birth and other particulars from the birth certificate accompanied by the assigned Social Security number, the state claims an interest in every child within its jurisdiction. The state will, if it deems necessary, nullify your parental rights and appoint a guardian, trustee, over your children. The subject of every birth certificate is a child. The child is a valuable asset, which, if properly trained, can contribute the valuable assets provided by its labor for many years. It is presumed by those who have researched the issue that the child itself is the asset of the trust established by the birth certificate. And the Social Security number is a numbering registration of the trust, allowing for the trust assets to be tracked. If this information is true, and we know it is, our children are owned by the state. We are now designated by the government as human resources, born in a delivery room, delivered to the state by birth of the way of the birth certificate, for which the informer, our moms, provides the requested information, including the name and Social Security or tracking number, wherewith the bankruptcy in the government is supplied with a new crop of collateral born every year. So these COVID-19 babies, since everybody's been locked down, they're going to find out there's going to be a new brand of collateral. So the people who passed away, there's no loss. We'll talk about that later. 1923, a suit was brought against the federal officials, a corporation charged with the administration of the Maternity Act, who were citizens of another state, to enjoin them from enforcing it, wherein the plaintiff averred, there's that word again, that the act was unconstitutional and that its purpose was to induce the states to yield sovereign rights reserved by them through the Federal Constitution's 10th Amendment and not granted to the federal government, and that the burden of the appropriations falls unequally upon the several states, held that as the taxation which falls not on the state but on its inhabitants, who are within the federal as well as the state taxing power, the complaint resolves down to the naked contention that Congress has usurped reserved powers from the states by the mere enactment of the statute, though nothing has been or is to be done under it without their consent. If you want the case law in regards to that, contact me personally. It's Commonwealth of Massachusetts. We'll get there later. Number 1, the act is unconstitutional. It purports to vest in agencies of the federal government or corporation powers which are almost wholly undefined in matters relating to maternity and infancy, and to authorize appropriations of federal funds and for the purpose of the act. What I will say, it's a usurpation of personal economic energy from the people, as I said earlier. We'll proceed. Many examples may be given or stated in debates in the Bill of Congress of regulations which may be imposed under the act. The forced registration of pregnancy, government prenatal examination of expectant mothers, restrictions on the right of a woman to secure the services of a midwife or physician of her own selection are all measures of which people of those states which accept its provisions may be subjected. 14th Amendment subjection. There is nothing which prohibits the payment of subsidies out of federal appropriations. Watch that. Insurance of mothers may be made compulsory. The teaching of birth control and physical inspection of persons about to marry may be required by Section 4 of the Act. The Children's Bureau is given all the necessary powers to cooperate within the state agencies of the administration of the Act. Hence, it is given the powers of assist in plans without which the boards may supply, as to which those plans shall provide. The final arbiters are the Bureau and the Board. The fact that it was considered necessary in explicit terms to preserve from invasion by federal officials the right of the parents to custody and care of his child in the sanctity of his home shows how far-reaching are the powers which were intended to be granted by the Act. That's why I don't have children. And for good reason. Number one, the Act is invalid because it assumes power is not granted to Congress and usurps the local police power, McCullough versus Maryland. In most recent cases, however, the court has shown that there are limits to the power of Congress to pass legislation purporting to be based upon one of those powers expressly granted to Congress, which in fact usurps the reserved powers of the states, and that laws showing on their face detailed regulations of the matter wholly within the police power of the states will be held to be unconstitutional, although they purport to be passed in the exercise of some constitutional power. Hammer versus Dagenhart. Search the case law. The Act is not made valid by the circumstance that the federal powers are to be exercised only within respect to those states which accept the Act. For Congress cannot assume, and state legislatures cannot yield to the powers reserved by the states for the Constitution. A message of President Monroe, May 4th, 1822. Number 4, LA's Debates, page 525. We'll leave it there. This is gold. This is gold now. This is gold. Y'all looking for money. This is money. This is more than money. More than what it could ever be. Section 2, the Act is invalid because it imposes on each state an illegal option to either yield a part of its powers reserved by the 10th Amendment or to give up a share of appropriations under the Act. A statute attempting by imposing conditions upon a general privilege to exact the waiver of a constitutional right is null and void. Harrison versus St. Louis case law. Number 3, the Act is invalid because it sets up a system of government by cooperation between the federal government, a corporation, and certain other states, not provided by the Constitution. Congress cannot make laws for the states, and it cannot delegate to the states the power for it to make laws for the United States. In reference, Raber 140, United States 545. And we'll leave it there. The Maternity Act was eventually repealed, but parts of it have been found in other legislative acts. Was this act attempted to do what it was set up, government by appointment, run by bureaucrats with redelegated authority to tax, which in and of itself is unconstitutional. What was once declared unconstitutional by the Supreme Court of this nation in the past should be upheld in the court challenge today. The Constitution has not changed. What has changed is the way that the government views human life as human resources. Today we are defined as human resources, believed to be owned by the government. The government now wants us as individuals to be tagged and tracked. Government mandated or legislated national ID, which is unconstitutional. Federal jurisdiction to legislate for the several states does not exist and could never survive a court challenge as shown above. Writing in letters to elected public servants will not save us and could never save us when we all know their agenda does not include serving those who place them in power, which is servitude. Perhaps the 10th Amendment of the Federal Constitution, guaranteeing states' rights, not people's, will, if challenged, when making it known that we as individuals of the several states will not be treated as chattel of the United States government, if the federal government believes that they own us and has such rights to demand national ID cards and health ID cards, which will in truth tag us as we tag our animals, then let them bring forth the documents to prove their authority to legislate for it. If our creator-given rights to life, liberty, freedom, pursuit of happiness, which is just property, which was the foundation upon which his nature was created, do not exist, and liberty and freedom is only an illusion under which the American people suffer. then let the government of this nation come forward and tell the people. But if we are judge-free, then we should not have to plead or beg for our elected officials and public servants, who are our servants, to be treated as such. If in truth we're not free, then perhaps it is our duty to address this issue forthright and forthwith with the power of the pen. And maybe the people will awaken from the fear and slumber induced by greed. And I close there. As I said before, if people want this information, you have to contact me privately. I can't place this out there in the public venue because, for the simple fact of the matter, is just that there's so many groups and disassociations and so many fragments of people who wish to commonly misappropriate the facts that are associated with the underlying fact that yes, people, you've been duped, you've been had, you've been misused, and people can't grasp that concept. They have so much of a personal leaning in regards to the procedure. And the procedure is based on laws, based upon procedural, historical precedent, not our own conjecture. So then we get an amalgamation of, everyone's idea on the subject. But this is, I read this, this is factual. This is factual. This is actual factual. And some people get, flustered within regards to the concepts because they have a shift in their thinking. And we're going to use a little bit of Bayesian inference in regards to this. To those who are educated and who know what I'm saying, Bayesian inference, for those who don't know, is a modeling approach that updates the probability of an event or hypothesis based on ongoing evidence and observations. So, however philosophically you apply that, this is realistic. Are you owned by the federal government? All depends on how you change your appellation in regards to being born under it. Whether you call yourself Moor, a Hebrew Israelite, whatever you call yourself, if you are not that on paper, it doesn't matter what you call yourself. You can live that in your personal life, but in your corporate sphere, what are you? And that's the big mistake that people have. There is no legal definition, according to the systematic indifference, to what a Moor is in any federal venue. Because you're considered citizens. If you were born here, you can call yourself whatever you want. But if you were born here by the statutory ideology that they recognize in regards to the status, then you're going to have an obstacle. You're going to have to fight between the personal belief and the realistic, legalistic belief, which only they acknowledge because in law, they don't acknowledge that. Because in the singular English sense, yes, we know what it means. But in the legalistic sense, there's no provision in law for what a Moor is. And that's the thing that people have to understand. And that's the thing that people have to understand. Because I got the facts with me. And I don't wish to debate the conjecture. Because I know that most people in today's society use archaic documents as supports and evidence. But the historical presence of it is that it's an archaic exposure of a concept that has been long outdated. And that's the problem with a lot of people. My channel is open to pretty much every walk of life. But I know that most people lean towards the ideology that I contact, more towards the Moorish ideology, so to speak, or the Hebrew Israelite community, or whatever you wish to call yourself. And like I said, I have no distinctions. I have no affiliations with no organization whatsoever. But it's just the principle. The principle is, if you're going to look at this, you have to look at it with accurate lenses. The historical precedent of 1921 and the implementation of the programmation of today is not your personal belief. That was post-1960. It was post-1960. Whatever movement, so to speak, was grafted in regards to the development of individuals of color was a movement that was designed to merge into the concept of civil rights. So the civil rights are just civil. They're not human. They're not realistic. They're civil, meaning statutory. Until people can grasp that concept by written, what's in black and white, they're not going to get out of their scenario. I rest my case, Stay tuned, people, for the next video in regards to the furtherance of the process. And for those who attend, I always welcome my videos to everybody, Haters in the comment section, don't make me no difference. I don't care. Don't make me no difference. And I'm going to keep doing this thing, Keep doing this thing. For the betterment of the understanding and enlightenment of the people who wish to know what the truth really is. I have zero tolerance for BS. That's a fact. All right? Love y'all. And agents, you know what it is. Peace. Take care.